Hey everybody, welcome to the Bold Today Show. I'm your host, JD Houvener with Bold Patents Law Firm. I'm the CEO and founder here, and I'm here every Wednesday, 9 a.m. Pacific and 12 noon on the East Coast. Happy to have everybody. So hopefully we get a good crowd today. We're talking about Veterans Day, and happy Veterans Day to all you, and thank you for all those out there that have served and helped us be free and live in this wonderful abundance that we're in every day. I wanted to honor veterans in the military and have a special sequence today highlighting some patents that have been granted that are sort of geared toward the military, and we'll just sort of keep top of mind some of those interesting innovations that happen even in the government, or some of those individual companies that may be contractors to the government as well. So welcome all those live attendees. You can see that my beard is getting longer as the days are getting shorter here as we approach winter. What I'm going to just put down some disclaimer language like I do every week. This is a live Q&A session, and I will prioritize those live questions as they come in. But just know this is not the right place to put legal questions. All right. So with respect to your confidential information. So let me just take that disclaimer and plug it in right there. Okay. So you guys have got the disclaimer. Let's go ahead and put in some additional language for you to get a copy of the book I've got, Bold Ideas, The Inventor's Guide to Patents. If you're on this channel, you're actually going to get a special link to my book here. We've got an electronic PDF download available on the website, Bold Ideas, The Inventor's Guide to Patents. This is your copy. Go to that link and book a free screening session with one of our advisors today to see if your invention, if you're far enough along the journey to really need our help. And we're pretty candid with, the fact that, hey, if you're not ready or you may need to get more education going, we will send you to some of our YouTube videos or our educational seminars to kind of get up to speed. We are big believers in having informed clients, and we do not want to have clients that are just sort of lost or feel, nervous about it and placing too much trust in us as professionals. We want to be there to support you in your journey. We are providing you patent protection, right? That's a super big asset, especially as a startup or an ongoing business that with ongoing revenue to use as leverage. We know that's not the only way you're going to make money. You've got to develop a business and be successful in other ways. So we make it a priority to give you those referrals, to listen to your whole story and really help you reach that goal in the end. All right, well, I just see one viewer. Thank you for hopping on. For anyone that's watching this after the fact, please give us a like if this is your first time seeing this. You like the fact that me as a patent attorney is up here talking with you and fielding live Q&A. I also want to welcome anyone that is coming in from our referral partner network or from avo.com, where I answer questions from the world as they come in to a voluntary system through the legal website called Avo, A-V-V-O. So we'll get to that at the end. If you are a novel listener, you want to fast forward to the end. That's where I'll usually be addressing those questions. So without further ado, I will start sharing some of these inventions, all right, from military, type of inventions, government-based inventions, things you might think of in that vein. I wanted to showcase some patents. I think that's one of the best ways to get those that are, just getting started or maybe already in the system to kind of get a better feel for what it is you're actually working toward when you work with a patent attorney. What's the goal? And hey, it's a patent that's granted. So what I did is I pulled some patents up from the USPTO this morning, and I want to share those with you today. So let me just share screen. And let's go to this first one. I thought this one was, I put the keywords in military protection and looked for inventions that were filed just this year. Okay, and this one was actually issued less than a month ago. So the rights were vested here in the upper right on October 13th. And this is for a composition having a plasma treated recycled steel fiber. It rolls off the tongue, right? I love the word composition. This is a specific type of patent, meaning it's not going to take on a specific form, meaning it doesn't have a shape or an actual apparatus or moving parts. It's a material, and so they're claiming, and we'll look at the claims down below, an actual substance, a new type of material that's sort of irrelevant with respect to dimensions or even proportions. It's a new material. They're adding things that haven't been put together before. In this case, plasma treated steel fiber, not just regular steel fibers, but it's recycled steel fibers. I imagine this is quite useful in terms of what it does, and we'll have to read down below in terms to find out what it does. Okay, so let's look at the summary. Okay, and so this is kind of where I would go to kind of get the gist of what this is about. So they've got macrofibers, microfibers, and what it's doing is it's removing the surface oxides and increasing the hydrophilic property. So it means it's going to be more absorbent and improve adhesion. Potentially lots of applications for this, for maybe in garments or within a a structure, stable shield type operation. What I want to do is go down to the claims and see how this was, what they actually own. And you can see going way to the bottom here, this is quite specific here. Goodness, you can see claim 1 goes all the way down this page and almost halfway down the second one. And you see the second claim is a jersey barrier. So it looks like I was actually wrong. So they say in the title, and this is why titles can be deceiving. And the title is composition, okay? But what they've actually claimed here is a method of producing. And so they've got a cleaned recycled steel macro fibers. They've got some specificity actually with respect to how big they are. It can be a range, between 18 and 38 millimeters, and certain diameters as well. So they've kind of defined what a macro fiber is. And they've got steel, they're cleaned. They must be selected from a group. Surface modified, okay. They must have surface energy modifying recycled steel macrofibers. The wettability, those word. Mixing, all right, these first constituents. And so they've got to use, they use a term called a Blaine fineness. Must be some sort of a industry known standard in terms of what these fibers are. And they provide a ratio once it's been cemented, right? So they have a cement mixed in with these fibers. Then you've got to mix the second. So after you've got this now turned into a cement, you've now got to mix in water, all right? Then you've got to mix in a paste, okay, some sort of a paste. Then you've got to blend it into a uniform container, okay? So as of a container, distributed properly. Then you've got to form it into some sort of a shape. Doesn't say what kind, but you can use any type of casting or molding or form. And then you've got to cure it. Okay, so there's 9 steps to that method, very specific method. So what they own a 9-step method. And what I'm guessing is that the owner of this patent has determined that there's really no other way to make this type of material unless you follow those 9 steps. If you don't do these 9, then you're probably going to get an inferior product. But you want to make for sure that that's the case before you go file a patent on it. If an infringer were to, let's say, just not cure, do everything, steps 1 through 8, but they don't cure it, they're not infringing. So it's very specific. I wanted to highlight that via that invention. Let me check back on our Q&A. I don't see any live questions right away. Thanks for those viewers. I'm going to jump to the next invention just to keep it lively. That was a cool live look at a method claim for a composition. This is for a ballistic panel for headwear. I thought this was kind of funny in a way, interesting. This was issued just over the summer, kind of spring, summer, June this year. Looks like a baseball hat, right? One that we probably all have like 2 or 3 in our closet. But it's actually a ballistic garment. And as I read this morning, this is a, for lack of a better word, it's a bulletproof hat. And they go on to say that there's a real issue, and I believe it, with police and even military security. They tend to shy away from wearing full helmet, traditional ballistic helmets, because it seems, aggressive or may put folks off. You could just imagine, an officer pulls you over and walk up to your vehicle in a full helmet. That might put you on edge and make the conversation a little more difficult. So what they've done here is they've basically combined, segments and a plurality, which is a fancy word for, more than one, panels. And so it's actually made of, ballistic resistant material. And they go on to list different types of materials that could be used for that. But it's all in a sort of panel arrangement. And that's seems a very specific part of this. I always have to go down to the actual claims to make sure that's how they claimed it. And again, quite a lengthy first claim. A ballistic garment, okay, plurality of flexible panels that they do distinguish that it's on the head. The panels have no less than 6 panels, so they had to define that it has a number of 6 or more. So fewer than 6, there may have been some prior art with that related. Wherein each of the plurality of flexible panels has a first side and a second side. And then they're talking about how it's positioned and the contacts with respect to the side of the hat and the panels. So, someone who's looking to design around this one may be a little bit easier if you're able to come up with a hat that's got 5, okay, 5 panels, and you follow exactly here, you're not going to be infringing this patent. Okay, it's a very interesting way to read the patent claims to know whether you may or may not be infringing. 6 may be the magic number. Maybe there's a real, fundamental physical reason to have 6 for structural reasons. I don't know. I haven't done that research, but that is curious to find out. Okay. Let's see, Flavio, good to see you. Got a question. I'll just stop sharing so we're not going into warp zone. Do you know if this is true? Major cola brand never patented their formula. How is it possible if you have to disclose the ingredients for food? Well, I am not an expert on food labeling. All right, let's just do a disclaimer there. But I will say that it is still the case in present day that Coca-Cola has a trade secret on their recipe. Now, to meet FDA standards, right? Every one of us has seen those ingredients. You've got to put, the major components of what's in there. But you'll almost always see, especially if there's a trade secret involved, natural flavors. Okay, and that's the catch, right? In there, you've got the trade secret, and that's really kind of only half of what's trade secret. Isn't just what's in it; it's the method of them producing it. The best chemists out there can likely take the end product of Coca-Cola and find out what chemically, atomic level, what went into that Coca-Cola, but they probably can't tell you at what temperature it was heated at, what ingredients were added when that might impact the end product, right? How much carbonation was inserted at different phases. Maybe it was heated, maybe it was cooled, and that's not going to be evident in the final product. And that's one of the major tests as to whether you go after a patent or a trade secret is by the end product, right? What you're actually going to be selling to your customers. Is it reverse engineerable? Is it something that your competitor or someone like you could go and find out how you did it and reproduce it? If the answer is yes, you think they could easily reproduce it, you should seek patent protection. But if you don't think they can figure it out and you're sure of it, then you may want to keep it as a trade secret because it can endure well past that 20 years of the utility patent, just like Coca-Cola has for, I think, over 100 years, kept their trade secret. Okay, thanks for that question. That was awesome. I actually had that in one of my slide decks last year. As a good example. Let me share screens with you guys. Do a couple more examples. On honor of Veterans Day, we're looking at some military type inventions. So we looked at the new composition with the plasma reinforced recycled steel fibers, and we just looked at the ballistic hat. This is a firearm slide with a sloped bottom surface. I want to show you guys, and this was issued just in September, a couple months ago. It's a gun. It's a handgun. I think if anyone has ever seen a gun or fired a firearm, this looks just like any other gun, okay? And I do this because you don't have to be revolutionary, groundbreaking to have a patent. This is an improvement, okay? And this is a valid patent. This has been issued by the USPTO. Surely they're not the first ones that come up with a gun, but let's read on to see what indeed they did, come up with, and help you kind of frame. Oh, okay, maybe I could be an inventor. Maybe I really could file a patent and have a little niche, right, in terms of an improvement or modification to a current product, and be able to make money on that in the market. This is followed by Springfield, a pretty well-known gun manufacturer. So they're improving the load cartridges and the clip, also called. So they're improving what's called the slide assembly and the bolt assembly, and they're going to be able to push a cartridge by having a sloped bottom-facing surface. So it's almost kind of more ergonomic in a way, so that when you push that magazine or clip, it'll be easier for the user. Let's see how they highlight that in some of these images. So that's the general high-level gun. And so they're highlighting the slide here. Okay, this slide is 120. And they're just changing the angle. They're just subtly changing the angle so that it's going to be more ergonomic and easier to slide, to make it easier for that magazine or clip to join. So let's go ahead and read the claim and see how they define that and see what they actually own on this improvement. They kept the claim nice and short. An improvement for a slide for a firearm, the slide having a forward-facing breech face and a downward-facing surface that contacts a cartridge and a magazine received within the firearm when the slide forms part of the firearm. The downward-facing surface having a length along which the cartridge and the magazine slides during operation of the firearm, when the improvement comprises the downward-facing surface is sloped along the length of the cartridge and the magazine slides from a lower end adjacent to the breech face to an upper end positioned rearward to the breech face. So, if you ever fired a firearm, instead of being straight across where you're pulling that cartridge back, you're actually going to be pulling it uphill as you load it, so that when it releases, it'll actually be going downhill. All right, and so there's utility that's probably defined in this, but it's a modification, right? They change the way the gun cocks and fires and it interfaces with the magazine, and they own that. There's a lot of dependent claims that flow from that slide with claims 2 through 14. All right, let's go to our live to see if we have any missed live questions. I think we're good there. Let's do our last one here. I want to showcase a non-tangible product. This is a system or method. Okay, situational awareness systems and method. This was issued a couple of years ago, and a company named Cool Fire Solutions. So they've come up with this way to connect multiple platforms, you name it, Apple, Android, mobile devices, tablets, different devices within systems, stationary, to geotemporal data associated with various endpoint devices, and identifies urgent and emergency events to determine the appropriate endpoint to notify the content based on the user-defined roles and the nature of the event. So it'll basically know how much and where to inform people, kind of an emergency or urgency response system. Now this kind of sounds somewhat generic. When I first read this, I was like, yeah, I feel like that already has existed for a while. Doesn't seem too revolutionary. But I want to dig into the claim and kind of show you some of the way that methods and systems, in other words, software, is claimed. And so it's sideways for you guys, but you can see it's a flow chart in many cases. That's how you describe the system and the process of what you're claiming is novel. And so you're putting all this information into the cloud, right? And how the devices are connected to it. You just use images to kind of help you define how data and information flows between your different steps in the sequence. And so this is sort of a military is why this came up. It's known as a strategic application. The military calls it an OODA loop. I think OODA looks like it stands for operational Well, let's see. Observe, orient, decide, and act. Okay, this is an acronym there for the military, and it's being able to rapidly incorporate feedback into the next rounds of observations and make decisions. So it's kind of like live learning, quick implementation, that type of thing. So that's how this came up for the military. There's a lot of operations, I can imagine, and the need to have live interaction with different devices and several people with boots on the ground. The way this claim is set up is it's a method, as we thought. We've got to have an endpoint device, a server, a specific server that has a first and a second identifier. Endpoint device has to be able to transmit, right? Talk two ways. The receiving at the computer indication of event, so that it receives an event in a specific geography based on GPS, most likely. The server is determined to be within a notification threshold. Before transmitting, it receives it and then sort of analyzes it. And maybe that's kind of the catch here. So this two-way interaction is once it identifies the certain signal from the device, instead of simply sending it or transmitting it, it's going to sort of analyze it within the computer, the server, based on a predetermined set of tasks. All right, so it's kind of like having a filter, right? A custom filter on what's being sent back, not just a big flood of all data. It's sort of in a way prioritized or racked and stacked data. So I can certainly say that's been quite valuable with multiple endpoints. Very cool. So thank you for that. I'll stop sharing. Flavio, thanks for your question. Let's see. So you're saying if it's not making money or with respect to patents and the population is not using mainstream, how can it still be patented and why would an inventor spend thousands of dollars? Let's see if I get that. Oh, well, okay. So, I mean, this is big. So, why would you invest in getting a patent for your technology? That's a huge question and something that should be investigated well before you go hire a law firm. And I always talk about this in terms of the patent success matrix. I have got a tutorial on that. Let me see if I can find it. Yeah, here we go. So this is a part of our website I want to share with you guys. You search patent success matrix. And I'm a big proponent of really fully understanding you need to be patentable, right? I talk a lot about that. I mean, it has to be eligible, has to be new, first of its kind in the world, and it can't be an obvious version of something else already done. But don't forget that in order for you to be successful, right, make money, you've got to have it be marketable as well, okay? And so that means you've got to have the right industry, market size. Is the market big enough? Do you have enough hedge over your competition? How many competitors are there? And how hard is it to get started, right? How much investment dollars do you need? If you're trying to enter into the the manufacturing of airplanes, how much is it going to impact you, right? Are you going to have to invest in a factory and hire machinists, or is it something you can just get started from your home office? So understanding, hey, if it's marginally marketable but very patentable, you can still be in this yellow-green and still be successful. And on the other end, you can have you've got somewhat narrow patent rights, but gosh, there's a huge market opportunity. It can still be worthwhile too. Obviously, the best in both worlds is you've got a super novel invention, and there's a big market. You're up in the dark green. So I'll post that link for you, Flavio. Thanks for your question on that. There's a matrix link. All right. Cool. Well, we got 3 more viewers. I'm going to wait 1 more minute because I do know it can take a minute or 2 for live questions to come in. So I'll just wait for that. I did publish a book earlier last year called You Are Not Alone, right there. This is a book about kind of the entrepreneurial journey and my own kind of story in a way about how I started the law firm. I know a lot of you out there maybe having ideas and maybe have side businesses or a current business, and you are the owner. You're the CEO, you're the principal. Everyone's looking at you, and it can be quite lonely. It can feel that way. So I do feel passionate about speaking to entrepreneurs that are inventing, even if you're not inventing. That could be a valuable book for you. So if you're interested, I'm going to provide my email. Just reach out. Feel free to get into contact with me if you've got any questions there about that. We don't see any questions from the live audience. I actually forgot to get to our OVO question. We've got a couple more minutes left. Let me just jump to that right now. And I'll share screen here. Okay, so OVO.com. There's a trademark question. Only one question came in out of Boca Raton, Florida. I am starting an online store, just setting the new company up and want to register a new brand. What's the best way to do it? I love this question. Really simple. You know, everybody's got this question. I don't mind answering it at all. I mean, this is for every single business, no matter what you're doing. If you're selling, you know, for profit, even if not for profit, you need to be worried about protecting your brand. You know, the hard work you're putting in toward communicating to your customers and clients, employees, right? Building up that culture. It all revolves around your brand and what you're setting yourself up to be. And so having a name or a design, you know, a logo, this is an important part about who you are, and hopefully, right, it'll endure for many, many years to come. So you want to think hard about what it'll look like, what you want your customers to think of you, and try to think long term. I always push clients to think that way with respect to trademarks, because it's not just what you're selling now, right? You've got an online store now, and maybe you're selling, you know, mugs or coffee mugs, right? But what might you sell? What do you want to sell 5 or even 10 years down the road? What do you see yourself doing? That's what you want to try to lock in protection for, to get that long-lasting, you know, broader coverage over what your business is about, what you want customers to see you as. So doing a trademark search is really important to make sure you're not going to be stepping on the toes of a company that already exists with the same or very similar sounding name. That way you'll avoid infringement. But even more importantly, you'll be able to have your own registration, and the application process will go smoothly. So I would say hire a trademark attorney. Bold Patents does offer trademark services. We'll be happy to talk with you about that. So good luck with your venture. All right, you guys. Well, let's wrap up. Thank you for tuning in for the Bold Today Show. I'm JD Houvener, Managing Partner and CEO here at Bold Patents Law Firm. I'm here every week. So if you missed the session or you want to come back next week, I'm here at 9 a.m. Pacific and 12 noon Eastern on the East Coast. Take care, everybody. Have a good day. Go big, go bold.